Hello everyone, welcome to my another MBA blog. Today our MBA topic is Legal Environment for Business MBA 20218 unit. So the introduction to business law. First of all we discuss about this. The law affects every aspects of our lives. It governs our conduct from the cradle to the grave, and its influence even extends from before our birth to after our death. Law is essential to any society in that it provides the rules by which people and businesses interacts. Law affects almost every functions and area of business. So what is law? Let's discuss about this. The law is a set of rules enforceable by the courts which regulate the government of the state and govern the relationship between the state and its citizens and between one citizen to another, or rules made by authority for the proper regulation of a community or society or for correct conduct in life. Nature of law. Law is at one and the same time essentially authoritative and essentially ideal. Law necessarily comprises both a real or factual and an ideal or critical dimension. A central element of its ideal dimension is a claim to correctness, which includes a claim to moral correctness. A central element of the real dimension of law is coercions of force. Now, ignorance of law excuses no one. This is a legal principle holding that a person who is unaware of a law may not escape liability for violating that law merely because one was unaware of its content. The Constitution of India is the supreme law of India. It is the longest written constitution of any sovereign country in the world. It came into effect on 26 January 1950. Business law encompasses all of the laws that dictate how to form and run a business. This includes all of the laws that govern how to start, buy, manage, and close or sell any type of business. Business laws establish the rules that all businesses should follow. Characteristics of business law: defining general rules of commerce, protecting business ideas and business assets, providing mechanisms that allow business people to determine how they will participate in business ventures and how much risk they will bear, ensuring that losses are borne by those principals for causing them, and facilitating planning by ensuring that commitments are honored. Now, sources of business laws: customs of history, that is trade, mercantile law, principles of equity, law of merchants, British statutory law, Indian statutory laws. The main sources of business law in India are: first, statutory law. Legislation or statutory is the most important source of law. Legislation is the making of law, but when we use the term legislation as a source of law, we mean law making by statutory authority. Both parliament and statement assemblies have enacted a number of legislations that cover various aspects of business. In England, a distinction is made between statute law or written law and the common law. Only the former is called legislation. In India, there is no common law. Here, legislations or enacted law is different from customary or personal law. Now, English mercantile law. The English mercantile law constitutes the foundation of which the superstructure of the Indian mercantile law, which being built our Sales of Goods Act, for instance, has been taken from the English Sales of Goods of Act. Even now, despite the enactment of various statutes relating to matter falling with the purview of the mercantile law, our courts generally take resource to the English law where some principles are not expressly dealt with the act or where there is ambiguity. Now, case law. The past judicial decision of courts are important source of law. Sometimes there is no statutory provisions which can answer a legal question raised in a lawsuit. In such cases, the court will look into previous court decision on similar matters to find the relevant law. Now, precedents law, past judicial decision. In common law legal systems, a precedent or authority is a legal case that establishes a principle or rules. This principle or rule is then used by the court or other judicial bodies used when deciding later cases with similar issues or facts. Now, Indian statute law. Statutory law or statute law is written law set down by a body of legislature or by a regular legislator in the case of absolute monarchy. This is as opposed to oral or customary law or regulatory law promulgated by the executive or common law of the judiciary. Statutes may originate with national state legislatures or local municipalities. Now, mercantile law is also known as lex mercatorium. So, what is lex mercatorial? It is the Latin expression for a body of trading principles used by merchants throughout Europe in the medieval. Literally, it means merchant law. It involves as a system of customs and practice which was enforced through a system of merchant courts along the main trade routes. Now, nature of business law. It is conduct, culture, tradition, religion developed by humans. It creates rights and duties. It ensures all the people have specific power and responsibility. It maintains peace and security. It provides justice and administrators punishment. It always aims to give justice to the victim and punishment to the law breakers. It regulates day to day activities, regulates internal activities also, defined by the Supreme Court. Now, scope of business law: constitutional law, criminal law, civil law, industrial law, labor law, commercial law, MRTP Act 1969, Environmental Protection Act 1986, Patent Act 1976, SICA Act 1985, Customer Protection Act 1986. Basic, basic dimensions to be covered under this subject. Now, contract, meaning Section 2H, an agreement enforceable by law is a contract. Therefore, a contract has two important elements. One is agreement and other is obligation, which is enforceable by law. First, agreement. Agreement is the outcome of the consensus between the parties who enter into a contract. That is, the promise made between them represents concurrence of their minds. Section 13. This would not be an agreement if the parties do agree but not on the same thing in the same sense, that is, consensus is not sufficient. There has to be consensus ad idem. Section 2E defines an agreement as every promise of every set of promises forming consideration for each other. A proposal, when accepted, becomes a promise. Now, offer. Offer or proposal. Agreement is equal to offer plus acceptance. Section 2A, when one person signifies to another his willingness to do or to abstain from doing anything with the view of obtaining the assent of the other to such act or abstinence, he is said to make a proposal. In order to create a valid contract, one party must make an offer, another party must accept the offer, and considerations must be exchanged. The one who makes the offer is known as the offerer, while the person who receives the offer is called the offeree. An offer refers to a promise that one party makes in exchange for another party's performance. In other words, it is an invitation to enter into a contract on certain items. Now, acceptance. Acceptance has been defined U/S section 2B as when the person to whom the proposal is made signifies his assent thereto. The proposal is said to be accepted. A proposal, when accepted, becomes a promise. A person who makes the promise is called the promissory or offerer, and the person to whom the proposal is made is known as promisee or offeree. In case an agreement is a set of promise, then a person becomes to a promissory and promisee. Thus, if there is an offer, acceptance, and consensus ad idem between the parties, there is an agreement. However, this agreement does not become a contract unless there is a corresponding obligation, that is, enforceability at law. Now, obligation. Section 10. It is the legal duty of a person to carry out what he has promised to do or not to do. All agreements are contracts if they are made by the free consent of the parties competent to enter into contract for a lawful consideration and with a lawful object and not hereby expressly declared to be void. Now, essential elements of a contract: capacity of a parties. Only those persons who are competent to enter into a contract can create a valid obligation. A major lunatic and drunkard, etc., suffer from flaw in capacity to contract, and therefore the contract made with them cannot be enforced against them. Now, free consent. Absence of consent does not create a legal obligation. For an agreement to become a contract, the parties to an agreement should give their consent to the agreement out of their own free will. It should be induced by coercions, undue influence, fraud, misrepresentations, etc. Now, the lawful coordination and object. Coordination means something in return. Consideration means something in return. That is, quid pro quo. A promises to give his wife to be for no money. Now that's the end of the video, my friends. In the next blog, I will discuss about the next points of the chapter. Thanks again for watching my videos, and if you like my blog, please subscribe and share my blog. For more support, I need your support, my friend. Have a good day.